Okay, so we're going to do the class a bit differently today. Just for a few minutes, it's probably only going to take about 15 minutes at a time of our time. We'll huddle around my computer and we'll be watching an actual juvenile confession. And afterwards, I actually have hard copies of, what transpired during that case, and we can use that to talk about the issues. So come on over, make yourselves comfortable, and I'll start it up. You can sit on either side or stand.
I'm not going to need notes or anything.
No, you don't need notes because afterwards I'm going to give you a handout and we'll talk about it and you can, take notes then. So we'll just sit and watch. There's 5 very short vignettes of the interview, and you can hardly hear her. You can hear the cops much more, but for the most part, she's not really saying much except crying, and then ultimately confessing. So,
the girl,
ready?
The girl. Okay.
Yeah. All right. So I'll wait till Amanda goes over.
And we can't turn off lights here right now.
No, you'll be able to see it. I mean, it's not. Okay.
No, I don't.
No, you know why? Because they're.
I'm not trusted. How so? What is the reason?
Because it's connected with other classrooms.
Okay.
So here's the first excerpt.
You tell us the truth, and I can guarantee you.
Okay, wait, hold on one second.
You didn't tell us the truth.
I'm going to go back.
Somebody
Yeah,
heard
see,
that
that's
baby.
the loudest.
Baby didn't suffocate on the mattress.
He picks up his voice. In fact, I had to shut the door in my office because he was so loud at one point.
You feel better. You didn't tell us the truth. Somebody heard that baby. Baby didn't suffocate on the mattress. There were only 2 people in that room, according to you and your mother, were you and Edmund. If you didn't do it, Edmund.
So she's crying. He's questioning her about her infant son's death.
I'm leaning toward you. You know why?
Yeah.
Do you know why?
She's saying, do you know why? Thanks.
Think about it. You're pissed at your mother. You have to keep taking care of all these kids.
So she's really not saying anything. She's crying. That's why you hear silence.
Who's Hen? Who's Hen? Trump. H-E-I-N Trump. Your brother? How did he pass away?
He's now asking about her brother. Infant just died, but her brother had died previously.
Sudden death syndrome. How about big sister syndrome?
Buffering.
No. You were watching him when he died, right? Is that not true?
You watching the big
Okay.
your brother. That
And
was
now you're
recently.
alone with another baby and he dies? Are we going to keep doing this? Or are you going to tell me what happened? You tell me what happened? His face was in the mattress? Oh, we're done here. Okay, thank you. Yeah, we're going to go now. Cut the shit!
I'm not lying.
Then Edwin
Not
did it.
lying.
One of you did it. Because that medical examiner told me that that baby was smothered. Does that change your story? Are you going to to argue with what a scientist has to say about how your baby died? Your story is going to be that he was sleeping with his face down on the mattress and that's all you know? We'll go with that. I'll go to court with that. I really don't care. But if you want us to hear yours...
Keep seeing it up here too.
How old is she?
Side of the story. You better damn well do it now.
Not mine. That's all I gotta say.
Really? Then how did Yen die? In your care. In your care. That baby mysteriously dies. And now Kyle's in your care and he mysteriously dies.
Kyle's her baby.
You're a liar. You just got the word. Worst luck in the world. How do you think a jury's going to see that? Now, you said earlier you're going to tell me the truth. I'm waiting.
Yeah.
No, you didn't. That baby was smothered. Somebody smothered him.
I will also send you guys in the online class.
You got some bad luck watching kids.
I want you to get an idea, though, so we can have a little discussion in class, even if...
But not really. Not really, because we know you're pissed because you have to keep taking care of your mother's kids. And all these other little kids. And you don't get to be a kid. That's what the problem is. And that's why you smothered Kyle, didn't you? That's why you smothered him, didn't you?
She lives with her mom, who's also very young, only 14 years older than her. And her mom has young kids, too, one of which, died from SIDS.
He did die from SIDS.
Yeah.
Your brother.
Yeah. Yeah.
Kill him.
I'm sorry?
We'll never kill him.
Really?
Sorry. Never kill him.
Kill him. We'll never do that.
Well, 2 babies have died in your care. It's kind of hard to believe at this point.
2 babies have died in your care. Okay, let's move to the next one. Now, the bad cop left. The bad cop.
Now it's good cop's turn.
Well, he's also not that good, but this one is shorter, so.
Sometimes we use that to say when people lose control, it was just a perfect storm. It was the baby, it was your mother, it was your life, okay? Maybe that just collided all at once and you lost it. But it's time to face up to that if that's what happened, okay? Because people will be much more understanding if
minimizing.
Patronizing.
I'll check this.
I'm just checking on something. I forgot what she asked.
How old was the baby?
Infant. Skip that one for now.
Is it okay to talk about this next time?
Was that
This
from
one
the
didn't
beginning?
No.
You don't care. Now you know what you did, and we know what you did. Based on all the evidence, there's no doubt what happened in there. All everyone's waiting for today is for you to admit to what you did so that we can start the process of getting you some help, getting you into a social program, getting your brothers out of that house, and get them in a better home, where there's a mom that gets up in the morning and takes care of them.
Is it okay to talk about this next time?
There's no next time. Why do you want to talk about it next time?
Because I'm telling you guys.
So what's going to change for next time? No, it goes like this. You tell us what happened. We walk right out here to special crimes, juvenile, get on the phone, talk to a social worker, and try to get you some help. Or
No,
you
it's
walk
taking
out
it
of there.
different. We'll tell us what happened, we'll get us some help, you were juvenile, etc.
Get his full report, get his findings, which indicate that Kyle was strangled and on his back when it happened, and I put my case together. One of those things is going to happen today.
When you say next time, is there something you feel you have to take care of before you admit to this, or what?
I just want to get Kyle feelings.
That's understandable.
I think there's one more, and there's an interview of her as well. Yeah, there's her interview. This is the one where she confesses.
Deserve a better life, and so are you. Not going to get that if we take this case through the court system. You're going to get that if we get you some help. If as a juvenile you admit to your frustration, your anger, what occurred, what happened, why it happened. I can't imagine anything more difficult than that, but once you do it, you'll be on the right path. Then maybe, just maybe, something good will come out of all this.
Forget, I don't see them. Yeah. I think this is as far as we're going to get with this. It's not even hanging with the... It's just totally frozen. Yeah.
What are you typing? I'll grab my computer. It's right on YouTube.
Oh, I got it. No, do I?
lost it. There it is. Forced confession. I think I'm going to skip to her interview. I'll tell you afterwards. How long is her interview? It's not that long. I won't lose it.
You can help me. You can get the number. The first thing you have to do is if you have a problem.
It's just showing
If
that
drags
this is
out,
when it
I'm gonna push
happened.
and try
So,
to see adults. I don't really care.
You tell us the truth, and I can guarantee you'll feel better.
Is that Lieutenant Johnson? Do you know this guy's name?
Every time I see
I've
it,
got it on
I
the
can't
handout. I'll
watch
give you in
He
one
sounds
second.
familiar. I'm from Worcester. I know that
You
voice.
stopped at your mother and you did something stupid.
I wanted to leave.
You told your mother I don't care
No,
about
this is
her.
her speaking
I don't
in the
care
background.
about you.
I feel like the only way to leave was to tell them what they want to hear. So I just told them that I did it. I will never, ever, in a million years, hurt my own child. I thought they was gonna let me go. I didn't know that they're gonna put handcuffs on me or put me in jail. I thought they was just gonna let me go because they heard what they wanted. When I first got there, I was put in, I was being processed. So we had to do a strip search first and then brought to our cell. But I was handcuffed and shackled because I was a new inmate. And plus I was on suicidal watch.
Nana took every program that the jail had to offer. She got her GED while she was there. She worked in the library. She read.
I never read books before I came to jail, but I pick up a habit of reading books every day. I read a book at least once a day when I was in the hole.
She hasn't been out of jail for, a year. It's been less than a year and she's already in college, working. In 4 months she's accomplished all that. Imagine what she could have accomplished in the 3 years she lost, or in the years to come.
Nobody told me that I was going to leave, and I didn't expect it. I thought it was just another day at the courthouse and then coming back to Chile. But when I came down in the basement and they took handcuffs off of me and they just let me go, I can't even explain it. Just thinking about it makes me smile because it was one of those moments where you feel like you can fly and I wanted to scream. I did scream.
Okay, so she got out. Almost done anyway.
Was that the day in appeal?
Okay, let me give you the hint. Oh,
I
she's
just
still
started to
talking.
cry.
All right, we're watching it. There she.
I feel like he's been with me the whole time I was there until today. He's been watching over me and helping me through all my struggles. I went to see him. And he's in the temple, so we usually go there and pray for the loved ones that passed away. So I went to see him. And I stayed for about 15 minutes. But on his anniversary, I bought a white balloon for him and wrote a message. The message saying that I love him and I miss him and that he doesn't have to worry about me anymore.
Okay, sorry about that, but I'm sending you the link. You can watch them all and hear them better. And I have a handout that is just the newspaper article that describes all of this. So let me hand that out. Oh, wait, that's mine. That's mine. Okay, what did I do with the one? Oh, here they are. Sorry, everybody has a, notice that if you look at the first page of this, the handout, in the middle where it says final video excerpt, I smothered Kyle. We didn't get to see and hear that. That was her confession. So basically, her son was not even a year old. He might have been like 14 months or something like that, I think. She was 16, lived with her, mom, and as I said before, mom had, young children as well. Her little brother had died, as one of the policemen said, while in, her care. And her son, who actually had been sick, died while in his crib. So she gets questioned by these two detectives who, as you saw on the video, the first questions her on the assumption that the child was smothered, and B, that she did it. And when you do see these on your own for the first, first 3, I think, vignettes, and you're just seeing some of the excerpts of her interrogation. She's constantly saying, no, I didn't do it, I didn't do anything, my little brother died of SIDS, blah, blah, blah. And the first officer is using this sort of maximization technique. It's also called the lead technique, right? Assuming sort of the person that the homicide was done by this person, rather than questioning the person to then arrive at that assumption. So after a series of that kind of interviewing, then the officers start to talk to her about her youth and her situation at home. Gee, you might have been overwhelmed, you're 16, you were taking care of the kids, you're taking care of your mother's kids, we need to have, maybe child welfare, help you guys out. And by the way, at the time of this interrogation, she had not buried her son yet. So, and she leaves the room, arrested in cuffs, and never attends her son's funeral. And at the time, what the officer, Peugeot is the first one, keeps telling her that the medical examiner gave him this information, when in fact that wasn't the truth. In fact, the autopsy that they had even had at the time stated no cause of death at the time. When they start to talk to her about being a juvenile, they're telling her things like, we're going to keep it in the juvenile court, keep it in the juvenile system, confess, you'll go into the juvenile system where punishment is minimal, if any. But then they temper it with, saying, oh, we can't make promises. Once she, quote, confesses, I smothered Kyle, her next statement, almost pretty much after that, is it okay if I leave now? She had no idea. So let's talk about first what you in terms of what you guys have read about juveniles' rights in these last few cases, as well as what you have read in the last 15 weeks as well. What was wrong with this interrogation and confession?
Laura?
Because she was a juvenile, there was no one there, no adult with her, a
Okay,
parent or
so
guardian.
what's the standard for that? And I gave you just 2 cases on that, I believe. I think I gave you Commonwealth v. Juvenile and McNeil. I think that's what I gave you guys. Yeah. So, Nicole, you tell us this? Okay, go
Do you
ahead.
want me to brief the case for you, or do you?
No,
Oh,
just
okay.
generally, use the cases to outline what her rights should have been.
Okay. Well, in Commonwealth v. Juvenile, the case stated that before an admission can be obtained from the juvenile as to his or her guilt or whatever, he must be advised of his Miranda rights and then be given the opportunity.
So let's stop there for a moment because, she ends up signing a confession and supposedly they advise her of her rights and whatnot. So does she, but when she's asked to go into the room for questioning, is she in custody? No, she doesn't even realize that she would have been free to leave, but for the confession at the end. Go ahead, I'm sorry.
So then after they gave her the Miranda rights, she should have been given the opportunity to talk with an adult who's informed and understands these rights to kind of explain to her what's going on so that she fully understands the rights that she was just given. Before she can sign a waiver for rights and whatever, she also needs to, that adult needs to be there as well to kind of explain to her what rights she's giving up before she actually leaves.
Yeah, now you didn't see it, and I'm not sure if it's on the video excerpts, but it's in the materials, I believe. It may be in this newspaper excerpt, I'm not sure, but at one point the cops mentioned, more than once, you talked to your mother, she talked to her mother on the phone. So they tried to say at some point, we satisfied the interested adults standard because, we gave her the opportunity to talk with her mom. And I don't know if all of you realize from the 2 cases that I've given you, but there's actually a difference in the children under 14 and the children over 14. Some of you are nodding, Mike?
Yeah, if they're under 14, it absolutely has to occur.
What has to?
That they have to have an adult present, and that the adult has to have, the adult themselves have to have an understanding of what the warnings are, and be able to express to the child what rights they're giving up.
Go ahead.
And if they're over 14, it wasn't that they, I think it was more that it should occur, but it wasn't that it wasn't as much of a automatic if it doesn't happen.
What is the term that the court uses for this, the juvenile consulting or not with the interested adult?
Interested adult rule.
Oh, yes, that's the rule, but in terms of what is it that the officers have to afford the juvenile?
The opportunity.
Yeah, and you'll hear the term, the meaningful opportunity, genuine opportunity. So in this case, as I said, the cops kept saying, "Oh, you talked to your mother on the phone." Well, that was one of the things the court found later on in the motion to suppress, which was allowed, that wasn't really a meaningful opportunity. Now she's over 14, so let's go a little further with that. So it's possible when the child is over 14 that the same safeguards for the child under 14 don't have to be present, right? And you could still get a valid waiver without adult presence, without consultation. But what needs to be there? Was that what you were going to say, Nicole?
No, I had a question about the mother on the phone, but we'll answer you first. Do you want me to answer your question?
Yeah,
okay.
yeah.
Well, they had said in Commonwealth v. McNeil that he was over 16 as well, and he said that he understood, as long as he understands and shows that there is no developmental delays or whatever it was that the court had said, that he needed to prove that he understood the rights he was waiving, and therefore it wasn't mandatory that an adult explain to him. If he says, I don't want my grandfather to explain to me, I don't want to talk to him, then the judge says that over 16, he's allowed to say that, and there doesn't need to be an adult explaining his rights in order for a waiver to go through.
Right, and also, actually, I'm looking for it, if this handout that I gave you talks about mother, I forgot where I read that. But in addition, it's actually the Commonwealth's burden to show that the juvenile that's over 14, that hasn't met with the interested adult, has, quote, a high degree of intelligence, experience, knowledge, and sophistication. And you'll see that in some of the cases as well. So, was that right violated for Nitron? I know I'm saying her name wrong, I'm sorry.
Well, that's another issue, that this English probably isn't her first language either, so that's another, does that factor into it at all?
Well, does it?
I would say yes.
Okay, so that might be one factor.
Yeah, that would go to the knowledge, I
Yeah.
think.
I mean, if there's a language barrier, she can't really, I mean, certain things they're saying, she may not fully understand what in the world they even mean. So she may need somebody to sit there and explain what they're talking about.
Although from hearing her not only post-prison, but on the video as well, she doesn't at least appear to have
Right.
heavy accident. It could be that her mother might have had some, and that's there's I believe an appellate case, an appeals court case, I think it's the Leon case, I can't remember, but both mother and son, had language issues. I think it's Leon, I forget. But the court still held that mother was in fact an interested adult. But anyway, that's another issue. So let's get back to her. So language possibly.
Her education even,
what's that?
Her level of education at the time.
Mm-hmm.
I mean, they said she did a lot of work in jail, that she was able to get her GED, and that was the first time she had ever read any books.
And also, again, she needs that genuine, you should have been able to hear on that video something like this. Obviously you have your Miranda rights, and then you have a right to an attorney, and you have a right to have your mother or someone in here that's going to help you, because you are a juvenile. And that's the other thing, you didn't hear that as well. At some point, one of the officers said they thought she was 17, and obviously at the time, that would have been adult status. That was another issue. But you have the opportunity, do you want to call your mother? Should your mother come in with you? Your mother can, consult with you, etc. There have been cases where a juvenile has said something like this in addition. Oh no, I've been in trouble before, I know the law. And that in and of itself also was not enough to satisfy the integrity of the police interrogation. What other issues surround her? Are you guys satisfied? Do you want to move on, or do you want to still talk about the interested adult?
I just want to ask a question.
Yeah.
In the cases, in both cases, they said that the adult needs to also, the police need to also kind of observe the adult and prove that the adult doesn't have any behavioral issues, any speech issues and things like that.
Exactly.
If she was only speaking to her mother on the phone, then how could the police have observed her?
Absolutely, and some issues that have been brought up in motions to suppress based on interested adult have been, does that person in fact satisfy the interested adult standard? So, mom came in and she was high. So how could she possibly, explain? There have been appellate court cases where a minor, which was I think an older sister and older brother, and the police tried to say, oh, they satisfied the interested adult standard, and that wasn't the case. A DYS, I think, counselor or somebody like that also tried to argue that he, satisfied the interested adult, and that didn't meet. Obviously, McNeil, grandfather, so it doesn't have to be mother or father, but it certainly has to, think of the word interested. Someone who's interested in the child's welfare that's going to understand enough about legally what's going on with the child, right? As well as care about what happens to the child. But here's a question for you. So, say you have a parent who just wants to slap the kid upside the head and say, "Tell the truth." What about something like that? And then the child confesses, and later the defense attorney says, "Well, I don't know if that was a valid confession because she really doesn't satisfy the interested adult standard." What do you guys think about that?
That was actually one of his cases.
Oh, it was that one of the cases
Yeah.
you?
The father said to stop lying, just tell the whole story, and the 12 and 13-year-old told it.
The kids that stole the sporting goods, right?
Huh?
The kids that stole the sporting goods,
Yeah, yeah. And,
Oh, Clifford.
they, no, it
I thought the
was
younger brother just read
a
it.
juvenile, Commonwealth v. Juvenile.
Oh, the very first case.
Yeah.
Yeah.
And it said that you also have to what Nicole had said, that the father needs to understand the warnings, explain them, but then also somewhere in here, I think it said.
That was actually the first case that set the standard. So there've been later cases that, then sort of modify the standard, make the standard clearer. Yeah, Nicole.
In McNeil, they also stated, the grandfather, they tried saying, it wasn't a parent, blah, 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 but they later said any adult that cares in the welfare of the child. So you can also argue if the parent, the child lives with the parent comes with the child to the precinct for the questioning, you can very well argue that that parent is involved and cares about the welfare of the child. So, I mean, even if the parent is frustrated and says, tell the truth, that parent is still caring about the welfare of the child because the parent could be knowledgeable enough to know that later on that kid's going to be found out anyway. So it would be easier on that child to just confess.
So that's one argument you can make.
Yeah.
Yeah. I don't think it's clearly answered either way by the court systems. So if you're a defense attorney, that might be one issue you pick up on and argue in a motion to suppress. Yeah.
Just something on the McNeil case that I caught on that I thought was interesting was when the grandfather later was trying to claim that he was drunk.
Yes.
And I was wondering, it said basically that the judge didn't believe his testimony, but I was curious whether in this particular case, if the police made any sort of records or notations of that he didn't appear drunk at the time or anything like that, or if it was just became the cop's word against the grandfather's word after the fact.
Well, it is also supposed to be an objective test, right? In terms of, do the police, understand that this person that has come in, mother, father, grandfather, etc., understands and is able to relate to the juvenile. So it's from the officer's point of view, does that person fit the interested adult standard? Yeah. Who knows? Was he drunk off his rocker and really couldn't give this kid any advice either way? Or was it just brought up again and, let's argue anything in this motion to suppress? Oh, I was drunk, so I didn't fit the interested adult standard. I was drunk, I was high, I was tired. I didn't know the legal system, so I told him to tell the truth. I didn't realize that meant he was going to go to DUIS. Or I didn't realize that meant, he indicted for murder.
Telling the truth doesn't mean you go to DUIS. Committing the crime does.
Yeah, exactly. Yeah, exactly. So what other issues surround sort of someone like Ms. Trun, who now has been brought in for questioning as a result of her confession, which, again, that we know that confession was held to be not valid much later on. What happens to her procedurally? Yeah.
Well, comparing to Commonwealth v. Wayne, they gave kind of like a process of what needs to happen for a juvenile.
I'm glad you brought up Wayne. So Wayne was a case that was decided under the old transfer hearing statute. And so what used to happen is they kept changing that transfer hearing statute.
And everybody would argue every time it got changed that it was, unconstitutional. So it went up to the SJC, and, that was one of the issues. But what about the issue regarding the expert? The psychiatric expert, yeah.
If a juvenile wants to kind of submit a psychiatric report, they can use that as kind of like a way to like prove their innocence and kind of like keep it in juvenile. Am I understanding it wrong?
So yeah, the juvenile was certainly using, submitting to his or her psychiatric expert, right?
Yeah.
But what was the Commonwealth arguing on appeal that the SJC actually agreed with? Amanda, did you?
That if they are going to offer their expert, that they are under, they can be ordered to be examined by the Commonwealth's expert as well?
Exactly, so it, leaves them open to be examined by the other side as well.
Right.
So that's really the importance of that case today, the psychiatric exam issue. Procedurally, the transfer process is not in place anymore. That doesn't mean, again, if you encountered sort of a case with these facts, you'd probably have, youthful offender, manslaughter, or Superior Court second-degree murder case, and then you'd still have a sentencing hearing if it was the youthful offender manslaughter case, and the sentencing hearing would be very much like the old transfer hearings. Yeah.
So then that probable cause for Part A doesn't count anymore, and then Part B where they
Right.
prove that's not at all. Okay.
Correct.
Okay.
Yeah, so that doesn't happen today. But those cases haven't been overruled because they've gone up on other issues as well. And again, even sentencing courts, say you have a youthful offender proceeding, and it's a rape case, or a kidnapping case, or a manslaughter case, they may still look to these earlier transfer cases because they still talk about rehabilitation and danger to society, public safety, which are still the same issues, if you guys get what I mean, at a sentencing hearing at the end of the youthful offender trial. So again, in that sense, they're not overruled, it's just that procedurally, it's different today, that's all. So I wanted to ask about other aspects of criminal rights, like bail review, dangerousness hearings, what you guys thought about. Would this juvenile be subjected to, the same sorts of procedures as an adult would if he or she is in, juvenile court? So the first thing that happens, or one of the first things that happen, after arrest, is they can be what's called detained. And remember, we read the Shaw v. Martin, the U.S. case that said pretrial, pretrial detainment, pretrial detention for juveniles is okay. We have that in our statute as well. And usually a parent is called, and usually the kid can go home with the parent, but there are circumstances like this one where Tron she went right from arrest, she didn't get to go home because she was charged with such a serious offense, murder, manslaughter, I forget what she was actually charged with, I think it was second-degree murder. So in that case, they're going to be detained and probably in a DYS facility, but not in a facility where adults are.
How about a Jenkins hearing?
A who?
A Jenkins hearing, probable cause?
Well, she will have a probable cause hearing. So it depends on, is the grand jury, is she going to be held and there's going to be just a grand jury indictment right off the bat? Or is there going to be a probable cause hearing in Superior Court? But in any event, she might still be held before any of that happens. And there might be reasons why they're held, right?
the dangerousness of the offense, the likelihood that the person is gonna, flee before, appearing for court. So the bail statute, the adult bail statute 27658 still applies to juveniles. The adult, have you guys heard of the dangerousness statute, which is 58A? It's a piece of, normally what is bail? What does a bail hearing consist of?
Person recognizance.
Yeah, well, you appear before the court, shortly after you're arraigned, or the same time as arraignment, and the judge asks, is the Commonwealth going to be arguing bail? And in many cases, the non-serious cases, et cetera, the Commonwealth says, no, I'm fine with, letting the defendant leave, and then it's continued from pretrial motions or whatever. Same thing happens with juveniles. But the Commonwealth could argue something else. No, I want bail. I want to make sure that this person comes back. And then the factors in arguing of bail have to do with, ties to the community. So is the kid going to school? Is he typically a runaway? And also, what is he charged with? What's the dangerousness of this offense? And when an adult gets imposed some kind of bail, and the adult wants to appeal that, doesn't like what the judge gave him, what can the adult do? Anybody know? So you get committed because you can't, make bail, or there's $1 million bail or whatever on you, and you just don't want to take it. You want to appeal that, right? What do? You just either stay in jail or try to get the money up or whatever the bail is. John, you don't know?
You can't just appeal the bail hearing?
Yeah. Do you appeal it to where?
Appellate court?
Actually, no. That's why I asked it. It's kind of a trick. We have what's called the bail review. And all it is you're appearing before a Superior Court judge who just reviews whatever that first judge imposed for bail. Again, and it's an adult procedure, but juveniles have that right as well, which is, it's kind of tricky and weird. So you're in juvenile court, right? And the court imposes some sort of bail on your kid, and you don't agree with that. You can actually go to Superior Court and have that reviewed and maybe changed by that Superior Court judge. That has nothing to do with the juvenile court. So again, some adult procedures that are in place for juvenile delinquency, juvenile youthful offender cases. John?
I was just going to ask, does it often get changed?
Sometimes. I mean, you have the opportunity to do that, so it's a right that you have that's identical to a right that an adult has. So, more of these due process rights that we've been talking about.
I'm just confused a little on what I brought up about the Jenkins hearing. I just want to fully understand whether...
Yeah,
So, like an adult, if an adult was arrested without a warrant, they're entitled to a Jenkins hearing within 24 hours to establish if there was probable cause for the arrest.
Oh, clerk's hearing. You talking about clerk's hearing?
No, a Jenkins hearing.
In district court? Okay, you're talking about a probable cause hearing, I think.
Yeah, it's called the Jenkins hearing.
Yeah, I call it a probable cause hearing because I'm one of the old folks, all right? So I'll give you an example of that. So say, you're going to be charged with rape. Well, it takes forever to get a grand jury indictment, right, for rape. So you're going to have a probable cause hearing, just like you're saying, in the district court. And the case might get dismissed, and you may, because there's not enough, and it's a very low threshold, right? And in the interim, if the court finds probable cause, they keep the district court case open until Superior Court, gets the indictment, and then the district court case would get dismissed, and the case would occur in Superior Court.
Okay. But they're still entitled to that same 24-hour window.
Yes, they are, again. So most of the due process rights are the same, and the reason why they're the same is it keeps going back to Galt, right? The potential loss of liberty. And then very few are not afforded because, like MacGyver v. Pennsylvania, the courts have sometimes gone back and said, well, look, these are really juvenile cases, and we're concerned about rehabilitation and not punishment and et cetera. But in Massachusetts, the rules of criminal procedure actually apply to juvenile proceedings. So every rule that you see, motion to suppress, motion for lack of criminal responsibility, all of those rules apply to juveniles as well. I started to talk before about the 58A, which was the dangerousness hearing, which is much more serious than just a bail hearing. And it actually, I forget, at some point, that became an issue, whether, I'm trying to remember the case, whether these dangerousness hearings should apply to juvenile proceedings, and I think I have it somewhere in my notes. It's either Victor V. Versus the Commonwealth. I don't even have the site in front of me. You don't need to really know it, but just know that the Supreme Judicial Court actually held that these pretrial detention provisions for people that, and they fit categories such as, say, domestic abuse cases, where the interest of the public and the interest of the victim is so high, and in balancing versus the due process rights of defendants, that it's more important to detain this defendant because of the public safety provisions, et cetera. And the Commonwealth actually has to prove after a hearing, and I think it's clear and convincing evidence, I forget, that this person would be dangerous, to the public if he was allowed free pending trial. There's another kind of, another sort of vehicle that actually helps kids, and it's a statute. It's part of the bail statute, and it has to do with what's called pretrial probation. Remember when we were talking about what's the worst case, let's talk about a kid that's going to do an admission for a delinquency case, and it's a real simple, never been in trouble before, maybe it's a simple assault or something like that, and so the kid does an admission to sufficient facts, and the court continues it without a finding, meaning that, within a year or whatever the period of time is, the case would get dismissed as so long as the kid, didn't get in trouble, etc. But that's still an admission. Nicole, have you dealt with them at all? Pretrial probation? So pretrial probation, nothing is really happening to the kid in terms of, he hasn't had to, he didn't go to trial, but on the other hand, the case can ultimately be disposed of if he sort of accomplishes the requirements of this probationary term. Again, similar to sort of like diversion, but he's already, in court and has been arraigned, but he has to agree to it, this pretrial probation period. So that's another sort of vehicle that is peculiar to the juvenile court in terms of rehabilitation and protection of the juvenile. I'm thinking of this defendant again that you saw in the video, and I'm wondering if we talked about all her possible issues. So she, remember the officers toward the end were telling her, well, you'll go to juvenile court. She didn't go to juvenile court. So what's the issue there?
I thought for murder you cannot.
Yeah.
At her age.
Yeah. Yeah. Yeah.
So then wouldn't that be almost like a coordinate, a lie to get what you're looking for?
Yeah, so what would have been her, if her confession didn't get thrown out, and if the case didn't ultimately go away and she was set free, what would have been the procedure against her. So she walks out of that interrogation room, and then what?
Say that question again.
Okay.
So, she's free to go, she walks out, she
No,
lets-
she walks out of the interrogation room and gets arrested for murder
Oh,
of her child, right?
Should get arraigned in adult court, right?
Yes.
well, she's gonna file the same motion to suppress for, not having
Yeah, but
proper
that's sort of
Miranda.
down the line. What is what is the procedure against her where she's charged with murder versus if it really was juvenile court, as the officers were saying to her?
Can they take her right away? Because
Well, either way, they can take her, and she would have, because she's a child, if she's going to be detained, she's going to be in DYS. But her case, her trial is going to be held in Superior Court, and she's charged with murder.
So she can go away for life. Versus staying.
Yeah, at the time, the combination of our statutory structure in Massachusetts was that if you were a child between 14 to 17, right, and you were charged with murder one, and the trial occurred in Superior Court, and if the Commonwealth proved, and the trial occurs in Superior Court, right, because the juvenile court doesn't have jurisdiction of murder cases, and so the Commonwealth proves the elements of the crime. Now, in this case, I'm just go back in time and pretend they have a confession. She says she smothered him. She said she smothered him with a stuffed bear. It's iffy, coroner-wise. There was another child that died similarly. If the confession is not thrown out, then it's possible the Commonwealth can prove all the elements of murder, right? And you said, Nicole, before she goes to jail for life. And the reason she does is because the combination, and this is before, obviously, Miller v. Alabama, that you guys have read, and before Diachenko and Brown that we talked about the other day. But the reason why she goes away for life is 265-2 never differentiated between juveniles and adults, right? Because murder one, punishment for murder one in Massachusetts is mandatory life without parole. Right? So they're telling her at the time, in 2008, no worries, you're going to juvenile court. Well, even if she was going to juvenile court, it would have been from manslaughter, and she still could receive, no, I'm sorry, never mind. No, she was going to adult court 2008. Yeah, never mind. Youthful offender was after that. So yeah, if it was manslaughter, she would be in juvenile court. But she could still get an adult sentence. So they're telling her, no worries, social services will take care of you. And she's thinking, oh, can I go now? Oh, I can't do it. I need to go to my baby's funeral. She has no idea. And it goes back to our beginning conversation when we talked about this. You really have, as the term says, this high degree, right, of sophistication, intelligence, knowledge, etc., to waive these rights.
Yeah, never mind her
right.
Educational and whatnot. What about like the shock or trauma of losing a baby?
Exactly. Exactly. So obviously this was an extreme case, but I think it was a good case to use to discuss some of these issues. Commonwealth v. Matthews was an interesting case because I've talked about that a little bit. And again, even though that was a transfer case, what's important about that case? Decided back in 1990. Because again, and I can't say this enough times, a juvenile court judge hearing a homicide trial, and that would be a manslaughter trial, is still going to go through the same kind of hearing that the juvenile court judge went through back in Rod Matthews' time, because the standards are very, very similar, right? What did Rod Matthews do?
So that's the one where he beat the kid in the head with a baseball bat?
Yes, that is the one. He did hit the kid on the head with a baseball bat. What else, Nicole?
He bragged about it.
He bragged about it. He said, come on over after school. I got something to show you. It's a dead body. It's so-and-so who I just killed yesterday. And so, Stephanie?
I was just gonna say, he strategically planted the body and continuously went back and forth.
Yeah, with his footprints in his footprints, so it didn't look like he went there with anyone. It looked like he was
Yeah, so if you had a case like that today, and say it was just manslaughter for purposes of youthful offender for now, what considerations, what factors would the judge take into account in the sentencing hearing? Yeah, Nicole.
He would try to see if the child was a danger to the public, and
Yep.
if whether or not he could be rehabilitated in order to be a good youth again. But if they rule that he can't be rehabilitated, then it has to be moved to Superior Court.
No. So it's your manslaughter case, and it's a youthful offender trial. So remember that everything you said was correct except the end. So at the conclusion of that hearing that you just talked about, the judge has three options, right?
Depending on the
Relative to what to do with him, right? Disposition-wise. Stephanie?
I was gonna ask, depending on the age,
No, the age is he's already in the age bracket of 14 to 17, 14 to 18 today. I keep saying 17 because that, until September, that was the case. What are the three choices the judge would have today after his sentencing here, after his youthful offender sentencing hearing? Heard all these horrible things, and maybe, I'm also hearing horrible things about what he did, but maybe I'm also hearing, I'll make up some stuff. Oh, he was good. Well, I know that he never did anything before that. He, by the way, was that was the time when we just began to medicate kids at that time, and he was on Ritalin. And it wasn't a huge issue at his trial for some reason or another. But let's throw that in, okay? He's on, Ritalin for behavioral problems. He committed this offense, not only committed it, invited people after school to view the body. Okay, so the judge hears all of this stuff. After the Commonwealth rested, the judge hears all of this stuff at the sentencing hearing. Now the judge has to decide what to do with him, right? So what are the three choices the judge has?
he can reduce the verdict.
What?
He can reduce the verdict.
No, there's no motion before the judge. This is the sentencing hearing.
Oh, the sentence.
The trial occurred in juvenile court. It was a youthful offender trial. What am I going to do with him now? I found that the Commonwealth met its burden. I'm not dismissing the case for manslaughter. What are my choices if I'm the judge? John?
Life with the possibility of parole in 15 years.
Well, you're thinking second-degree murder, and I don't need you to be that specific. The general three choices at any youthful offender trial.
Give the adult sentence?
Yeah, give the worst case scenario is I'm going to give that kid whatever an adult would get. So if manslaughter is, I'm making this up, I think it's 20 years, something like that, then that's what he's going to get. So worst case, and then the middle approach is the combination sentence. He's going to go to DYS, and then later on, Department of Corrections. And then the least intrusive is DYS, which is the same thing he would have gotten if he had been, if he had a delinquency trial. So those are the only three options if the Commonwealth proves its case for it. And if it's the juvenile court and it's the youthful offender hearing, as opposed to, John, what you just said, that would have been the option if instead he had been charged with murder and he was in Superior Court. And again, because Miller v. Alabama ruled that mandatory life without parole unless you have a sentencing hearing, and because Massachusetts went even further than that and said no life without parole, period, if this case was tried in Superior Court, yes, then you would be right. Then he would have life with parole. Yeah.
If the judge went with the least restrictive, just
The DYS.
sending them to DYS,
Yeah.
is that when it's up until age of majority, or if they're already at that age
Yeah,
for 1
it's
year?
18, and sometimes it goes to 21, and, but in any event, it's DYS and DYS only. Yeah.
So once they reach that 18, 21 range, what happens to their record? It's not clean, is it?
No,
Oh.
no. None of these records are. None of these records are. You've heard of kids that they think that, oh, I admitted to sufficient facts. Now I'm, I want to be a cop, or I want to go in the service. And then, you can ultimately try to seal and expunge the, and there are statutes relative to that. But you do, have a record. That's why the diversionary techniques that have been used are great. Because when you're talking about pretrial diversion, it's the police, making sort of a choice and, using other methods, why can't I say that word? That's, rather than having, once the kid's arraigned, once anyone's arraigned, you have a record, you're going to show up on inquiry. Anything else? Let me see. Oh, what was Clifford about? I know I skipped some over, but they're not that. Again, that was another case, transfer case, the statutory factors, the psychiatric testimony, whether the juvenile was amenable to rehabilitation.
Clifford had to do with transfer hearings, right?
What's that?
The transfer hearings?
Yep.
Was it, well, one of the things I highlighted here was about the difference between they only had to show by a preponderance of the evidence instead of clear and convincing evidence.
Yeah, as I said, back then, that isn't anything you have to know, because that procedure isn't happening anymore. What's important when you read these cases is, what did the juvenile do? What was the act itself? And then also, what do we know about the juvenile in terms of his or her amenability to rehabilitation? Because again, those would be the factors that the juvenile court judge would still look at today for these sentencing hearings that we just talked about. So he had all kinds of problems, Clifford, right?
Yeah. So it laid out
Go
a
ahead.
bunch of I thought there were two things out of this. One is there were a bunch of factors for the judge to take into account, and the second was that the judge wanted to avoid battle of the experts. So because he thought the introduction of evidence would be cumulative, so he didn't let anyone bring in expert testimony. And I think they reversed that part of it and said both should come in, because then they could both be cross-examined, but not to avoid that. So they talked about how
My question before too was about him himself.
he regularly carried weapons.
Yeah.
So he's the one. He was with another boy, and then the father and the son were the third boy and the father, and a fight started, and he pinned the son and stabbed him.
So that was the act. Now what about him?
So they said that he was an habitual assaulter. His violence had intensified over time. He was a drug dealer. He may have been involved in gang activities. He had aggressive tendencies, impulsive behavior, low self-esteem, a poor, insufficient family situation, regularly carried weapons. So they didn't think.
And a lot of that might have been a result too of his poor family situation as well.
Right.
And that was the problem with the judge not sort of considering all that, right?
Yeah. And then they said that they didn't think he'd be amenable to rehabilitation because he had a lack of success on previous treatment efforts. He had the juvenile record of violence, lack of academic effort, truancy,
Okay.
history of substance abuse.
And that's when you want to talk about if you see facts like that in question relative to the sentencing hearing piece of it. And again, whether and which one of those three choices that we just talked about should the judge make after a sentencing hearing. All right, I remember I said to you that we would decide about search and seizure, and I think I've made the decision that I will not cover search and seizure, which means search and seizure will not be on the exam. You know, you're free to, if you ever encounter those issues. There's lots of stuff in mass practice and CLEs, as well as the basic standards that we have is the federal standard in the TLO case that I read you, and that's reasonable suspicion because these are school officials and not police. And then we have variations on that as well. But it's that, you know, and the test is, was the search justified at its inception, and was it reasonable in scope? And again, that has to do with, you know, school officials, search and seizure. Mass has some cases that, you know, go back and forth in terms of, you know, should we raise the standard, but it's all dependent on, you know, the school officials actually acting like the police. And there are variations on that, where, you know, if a resource officer is involved, does that mean the kid's in custody and so forth? But it's interesting, and, you know, if you represent a juvenile that has obviously been searched, then you would be filing a motion to suppress no matter what, arguing those cases. So you have the cases and you can go further, you know, with those in your research. So the other good news with regard to that is because I decided not to cover it, we won't have class on Tuesday. So I would prefer, and the reason why I'm saying that is we have oral arguments all day on Tuesday morning, almost into, well, actually, and then picking up again through the evening. So I'd rather do the final review on Thursday, if that's okay with all of you. So no class on Tuesday, but we'll do the final review on Thursday. And I actually send you a checklist of issues that you might encounter. And it's just like terms like best interest of the child, etc. And we'll go through, I think there's about 20 of them or something. So I'll send it to you by email, and we can actually go through all of those terms in our review. Laura, did you have a question?
Yeah, on Thursday, can we reset a little bit on the juvenile processes, but in Massachusetts? Because
absolutely, anything, you know, and again, most of, you'll see that the review pretty much covers all of that, and then, you know, there's room for additional questions and whatnot. Yeah.
I got really off track. I think a couple people did on the Part A and Part B in the transfer hearing,
Yeah.
and I feel like I went the wrong way.
Yeah, no, and it's it absolutely is confusing because those cases are not overruled.
Right.
So that's why it's confusing. Or one of the reasons why it's confusing anyway. I will also email you the link to this video. It's a really astounding case and astounding piece of work. I actually was, how I found out about this case was through a, a seminar conference at Suffolk Law last year, in which not only the attorney for trying was there, but Judge Agnes actually also spoke, and he spoke about this read technique that police officers, you know, use sometimes, which you'll see in more, actually in better detail than what I just showed you in class, because we could hardly hear or see it, but if you access it on your own computer, you should be able to. It's still really quiet, but if you're alone and you don't have the computer close, you should be able to hear it all. There's 5 excerpts, and then there's some other stuff on it.
So are there actually rules in place for confessions? Do they have standards that they have to go by at all, the police officers?
No, okay. Oh, well, police, yeah, of course they do. And the rules are constitutional law, everything we've been talking about. Don't violate the
On the day
defendant's
of our
rights.
final, it is at 4, right?
No, I think it's at
Is
6.
it 6?
Oh, okay.
I think it's at 6.
Because of
Yeah.
that class, I mean.
Yeah, I'm pretty sure it's at
Class.
6, yeah.
Okay.
Is some, I thought I saw somewhere open book, is it open book or?
No.
Okay.
No,
Maybe there's some old midterm.
I
or
would
something.
grade you harder. You don't want open book,
Well,
believe me.
it's something
You'd be
you wrote-
going crazy just trying to get everything together and be
Yeah.
specific.
Whatever it was.
I like
it's
our new
open
chalkboard.
book. Because it's open book, I expect sites
Yeah.
or something like
No,
that.
yeah,
Okay.
right, no, closed book.